Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, presented for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Okay, good morning.
SJC-13119, Commonwealth v. Richard Comenzo.
Attorney Noonan.
Thank you very much. May it please the court. My name is Patrick Noonan. I represent the defendant appellant, Richard Comenzo, in this matter. I'd like to recognize co-counsel Attorney Scott Martin. I'd also like to recognize the amicis in this case. I appreciate their support. This case deals with a poll camera. In Commonwealth versus Moore, this court had found that the government's continuous use of a poll camera targeted at the residence of the defendants was a search under our state constitution. The co-defendant in Mora, who is defendant Suarez, the poll camera was pointed at his house for 8.5 weeks. The motion judge in this case correctly found that 15 days of poll camera surveillance targeted at Mr. Comenzo's residence was a search. The motion judge also correctly found that the appropriate unit of measurement to determine the search is the entire time the poll camera is up, which was 17 days in this case. The poll camera remained up 2 days after the search warrant was executed, even after Mr. Comenzo had been arrested and arraigned. Finally, because the defendant met his burden of proving a search, the burden shifted to the Commonwealth to prove both prongs of the Mora test. It is the defendant's contention that the Commonwealth did not meet its burden on prong 2 of the Mora test, which is at the time the poll camera surveillance began, the poll camera would produce evidence of a crime.
Well, that's not the only provision. Would produce evidence of a crime or would aid in the apprehension of a person who the applicant has probable cause to believe has committed an offense.
Yes, and there is 2 components to that second prong. For the aiding in the apprehension of the suspect, the poll camera in this case was not needed to apprehend Mr. Comenzo. Before they even engaged in any poll camera surveillance, the government knew where he lived. They knew his apartment building. They watched him come in and out of the front door. They even went to his law office. They even followed his vehicle. So they didn't need a poll camera to apprehend him. They could have picked him up anytime they wanted. They knew where he lived. They knew where his business was. They knew where his law practice was. So this wasn't a case where you had a fugitive or somebody whose whereabouts was unknown. They were surveilling Mr. Comenzo very closely. So I would say on the element of aiding in the apprehension, the poll camera was not necessary for that.
If they arrested him outside the home, then what happens to the evidence if they don't do a search?
Well, they would still need probable cause to arrest Mr. Comenzo. The Commonwealth states that they have probable cause that evidence of a crime would be contained somewhere inside 15 Walnut Ave, that there would be computers located somewhere inside 15 Walnut Ave. However, the Commonwealth would, in my opinion, have to establish more of a connection between Mr. Comenzo and the apartment where these images were supposedly uploaded.
Wouldn't a poll camera help do that?
I'm sorry, Your Honor?
Wouldn't a poll camera help do that?
The poll camera, in my opinion, would not, the reason why they requested this poll camera was not because it would produce evidence of a crime. It was because they didn't know the exact apartment and they needed this information to establish particularity to get the search warrant. So I don't believe that.
Counsel, let me
Yes, Your
test you on that point. So of the things that you say the Commonwealth was able to glean from the use of the poll camera, it wasn't good old-fashioned police work. Didn't it just parrot what they already knew? Because in the affidavit say they did old-fashioned stakeouts and they observed him coming in and out. They observed going into the dwelling and then the subsequent lights that would go on in particular areas or windows of the structure of the dwelling. So they had the stuff that they ended up getting from the poll camera. Wasn't it just duplicative of what they already physically observed?
I would say no, Your Honor. They they did do a traditional investigation, and they did do 10 days of surveillance before they got the poll camera. However, they were still stumped. They still did not know what floor and which apartments he was living in, because they had a lot of conflicting information as to where his precise
Well,
apartment or floor.
drill down on that for me. What specifically do you allege they got from the poll camera surveillance that helped localize it to a particular unit?
So to get back to your first question, which is they only got to a certain point where they had to use the poll camera. If they had probable cause.
Sure.
without the poll camera-
I'm conceding that point. Tell me specifically what you allege that they were able to take from the surveillance that they were not able to get from good old fashioned physical observation.
So the poll camera was continuously surveilling him. They were able to see his pattern in terms of every time he came home and went through the front door, the lights on the areas 1, 2, and 3 windows came up.
That's what I'm getting at. Didn't they already physically observe that prior to the poll camera?
They did on only one occasion. And when they did do that, they only observed the lights turn on in the area 3 window.
Mhm.
But when they did the surveillance with the poll camera, they saw that lights came on in the areas 1, 2, and 3 windows.
And how many times did they get information about that? How many different events?
So the detective relied on 10 days of poll camera surveillance.
Okay, and within those 10 days, how many times did he see the defendant come in and those windows come on?
Almost every time. I would, if I can just double check that, because it's nearly every time, save for maybe 1 or 2 occasions.
So you're saying 8 times it happened?
Yes. Let's see.
It's fine, we'll check the record. You can
Okay.
keep going.
Isn't this good police work? They have probable cause that somebody in this building is, downloading child pornography. And then, but they're not exactly sure which unit it is. So instead of getting a search warrant for the whole building, which was probably inappropriate, they get a search warrant for the poll camera, which allows them to pin down which unit they're going to search. So again, isn't that good police work and also good from a Article 14 perspective, because you particularize the search and narrow it down?
Well, I think Your Honor said, when in terms of good police work.
Well,
you said-
good Article 14 procedures, because we have probable cause and a limited search with the poll camera, but we don't enter into people's homes without having more precision about who is downloading the child porn. So isn't that good from an Article 14 perspective?
So the Commonwealth did do a good investigation, but that only took them to a certain point. They weren't able to pinpoint the floor or the apartments that he was living in.
Wasn't
that's
the
why they
IP address associated with apartment 315 Walnut Street and Mr. Comenzo?
Yes, so the IP address came back for the Tumblr account as being Richard Comenzo, apartment 3.
Why isn't that good enough?
Because we had all the other conflicting evidence
Mhm.
as to whether he lived in apartment 3.
But it's not certainty, it's probable cause, right?
Right, but there's also a real danger that the residence of another could have been searched in this case, because they had evidence conflicting that Mr. Comenzo either resided in apartment 2 or apartment 3. They also had evidence that another party, Nicholas Hill, was also either residing in apartment 2 and apartment 3.
And so given that confusion that you're articulating, wasn't the poll camera useful in aiding in the apprehension of Mr. Comenzo?
Well, again, I don't think it was necessary to aid
Not
his apprehension.
necessary. The question is, does it aid?
It did not. I'm sorry to interrupt there. It did not aid in the apprehension because they knew where to find him. They could have picked him up anytime.
But you're just articulating some level of confusion, given the mailbox saying it was Mr. Hill, apartment 3, Verizon says it's Comenzo.
But
Isn't it aid in a criminal investigation, what we're looking at?
so
So
that's,
let me ask you, so a search warrant issues for the entire building. 15 Walnut. You run into court and say no particularity because they're playing digital whack-a-mole. They can go into any apartment. That's no good, right? So instead, they use this technology. They get the apartment unit, and as Justice Capper says, now they have particularity, and your search warrant or the illegality of the search is dissipated by the apartment number. Didn't the use of the poll camera aid in the investigation of this crime?
So the Attorney General's position in their amicus is that the government need only show that the poll camera would somehow move the investigation forward or be helpful to the investigation, and they're trying to build off of the CSLI cases. But I would say in this particular circumstance, when you're dealing with a poll camera and a poll camera targeted at somebody's home, and also the advanced technology of the poll camera, that you have to establish more of a tighter nexus between.
How's that possible? In the CSLI cases, we've talked about the mosaic, and you can track people. It's a GPS. You can see where they're going. The poll camera is a fixed spot.
But-
You know, and you come and go, and that's it. Why should we have a different rule for the Augustine type cases than we do for poll cameras?
So it's a great question, and the
Thank
answer
you.
is, the answer is this: because poll camera surveillance is far more intrusive than CSLI ever could be.
Really?
Oh.
Yes, in my opinion, because
Okay.
with a CSLI, you're just trying to determine somebody's past whereabouts. at
Right,
specific
right,
locations.
and you can track them like a GPS. You can see whether they go to the political rally. You can see whether they go to their doctor's office. You can see, our cases have litanies of horror stories about the dangers of CSLI and tracking people, right?
But also CSLI in comparison to a poll camera.
And nationally, all the CSLI GPS cases are heavily weighed towards privacy. Mora is somewhat of an outlier nationally for poll camera and privacy interests, right?
So the reason why the poll camera is more intrusive than CSLI is because we're dealing with surveillance targeted at somebody's home.
But address that nationally, right? Supreme Court precedents. You look at all the federal cases on poll cameras, they say open spaces, you're good to go. We said
Also
something
examining it
different.
under
We
the
said
Fourth
something
Amendment.
different in Mora. And now you're arguing to us that poll camera is more restrictive than more of a privacy interest than CSLI.
I strongly believe that. The federal cases are only examining the poll cameras under the Fourth Amendment. But, in particular with a case like this, if you look at the record, the poll camera was incredibly intrusive. We had a poll camera that was 82 feet away from his front door. We had a poll camera that surveilled every single person that went into
Right,
that
so maybe
apartment building.
we're going to agree with you and Justice Cosgrove that there was a Fourth Amendment or Article 14 privacy interest. Then we go to the next step and more, right?
Right.
Right, and Justice.
Because the Commonwealth's going to argue that there was no privacy violation.
Well, the record strongly supports that there was a privacy.
Okay, so
intrusion.
all right,
Absolutely.
all right, for purposes of this, I'll agree with you. Now we have to confront the next step of more as far as whether it's going to aid in the investigation. And you're telling us when you have an IP address, you don't know what apartment it's in, that didn't aid in the investigation?
Well, again, I disagree with, the standard being that it has to aid in the investigation. I think that the standard has to be that the poll camera, when it goes up, has to produce evidence of a crime. And here, the Commonwealth even admits in their own brief that the poll camera didn't capture any illegal activity. And Mr. Comenzo didn't. commit
What's your support for that? Because again, as Justice Wendland already, before we even got to the poll camera, they got the administrative subpoena. They knew the IP address was localized to that structure, right? And they even had a name and apartment number, right? Even before the poll camera. So they didn't even need the poll camera to at least get them to the physical dwelling. I'm
Well-
still struggling with how it is that the poll camera would be necessary when they already knew all of that.
Well, if the poll camera was unnecessary, they would have just applied for the poll. They just would have applied for the search warrant without even going to the. poll
No,
camera.
it goes to the second point you made. So now trying to figure out which one of this is unit 3 or whatever the appropriate unit is, you said yourself that prior to that, they did physical surveillance and couldn't localize it. So how did the poll camera not help them particularize which unit it was. You said yourself, they couldn't do it without it. But then when they were able to look at the footage and say, he comes in, these lights go on, these lights are located in this particular unit. So now we know.
So I'm not sure if I understand your question. I'm sorry. Could you?
You're saying that the poll camera wasn't necessary to aid the investigation. But you've also said to us that they couldn't particularize the unit with the physical observations they had done prior to the poll camera. So now with the footage that they get from the poll camera as to your client going in and then subsequently which particular lights come on to be able to identify which unit he's in, how can you say it didn't aid in the investigation?
So it didn't aid in the apprehension of Mr. Comenzo.
I'm not talking about the apprehension, I'm talking about the investigation as to where the child pornography was being downloaded, in what unit, where that computer would be.
So the poll camera establishes his consistent pattern of every single day coming in and out and the lights going up on the second floor and pinpointing window 1, 2, and 3, which is information that was not something they could have gotten without the poll camera, because Detective Doherty admits that the poll camera gave us information that was otherwise unknowable to us, because she says that specifically that the reason for the poll camera is we cannot determine where he lives in this building, and we are hoping the poll camera will determine the same. So that's the reason why she is saying that we need a poll camera. She's not saying we need a poll camera because that's going to produce evidence of Mr. Comenzo committing a crime, or it's going to produce evidence of child pornography. She's requesting it so that we can find out the floor and the apartment, so we can get that particularity, so we can get the search warrant.
So
she's-
does he have a right of privacy in his floor and apartment? Of the identity of that?
Oh, I'm sorry.
I'm sorry. Does he have a right to privacy or privacy interest in what apartment he lives in and what floor he's on?
Well, I think so, because one of the things here is when you're doing this constant surveillance and they see the lights turning on the second floor and in certain windows, they know this is him, and they know every single time that
Right.
he's going to
but
bed.
that doesn't establish that he has a reasonable expectation of privacy in that information.
Well,
It
one
just
reason,
means they can see it that way.
well, one reason why somebody may want to live in a multi-level apartment building is because they maybe don't want to disclose exactly which apartment is theirs in the building.
Uh-huh.
And I do think somebody would have a reasonable expectation of privacy. And
And when their light goes on?
well, when their light goes on continuously and it's being recorded and the government can tell each time Mr. Comenzo goes to bed every single night and what time he wakes up every single morning by the lights going on in the morning and the lights going off at night. You're getting a window into this person's life. They're living in the apartment. You're tracking the movements with a precise log of every single time he gets up and every single time he goes to bed. I think I may be out of time.
Okay, any other questions? Thank you so much.
Thank you so much.
Okay, Attorney Cusick.
Good morning, Your Honors. May it please the court, my name is Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth is asking this court to affirm the motion judge's denial of the motion to suppress the search of the defendant's apartment, which was performed pursuant to a warrant, which did have some information from the poll camera in it. The judge applied the Mora test and found that the Commonwealth had satisfied the Mora test. That when the surveillance began, there was probable cause to believe a particular offense had been committed, and that the footage would aid in the apprehension of the perpetrator or produce evidence of the offense. And here, prior to any poll camera going up, the investigators knew that there was child sexual abuse material being uploaded from an IP address at that structure, 15 Walnut Avenue, that came back to Richard Comenzo. That alone was enough to suggest that there was probable cause that a crime was being committed at that location. Police had information that Mr. Comenzo was in apartment 2 based on National Grid records, or in apartment 3 based on the Verizon records. And there were other people associated with that physical address who also came back is associated with apartments 2 and 3. So here, a poll camera aided police in identifying which apartment was occupied by Mr. Comenzo. And when they searched to get the warrant to search it, to obtain electronic evidence of the offenses that were committed. It also aided in the identification and apprehension of the suspect. Certainly, Mr. Comenzo was connected to the IP address and the physical address of that building, but perhaps someone else had been committing this offense from that location. It aided in identifying Mr. Comenzo as being physically at that house and in connection with the IP address from which the child sexual assault material was uploaded. And certainly there's no requirement that they capture images of him at that address at the exact time of.
Can I ask about the point that Justice Wendland brought up, which is that the IP address identified the apartment number? How does it do that? Is that from the person who requested it? I mean, is that the kind of thing you can write down something inaccurate to keep people away from you? Or how do they know where the IP, how do they connect the IP address to apartment 3? I know they did it. How did they do it?
The Verizon record, so Verizon provided the internet service. Verizon had the service address, billing address as apartment 3.
Mhm.
So that was what police went on for that particular point. It's unclear in the record how Verizon came to have that address, whether it's something provided by the person when they sign up for the service or some other reason. But that is indeed the address that came
Because if
from
we have
Verizon.
a person using their computer for child pornography, they have some incentive to conceal, where they're doing that, right?
It's a reasonable inference. I'd suggest to certainly think that if you're going to use an electronic device and an internet connection, you might wish to not have that known exactly where it traces back to. But again, the record doesn't have a lot of information on that other than a lot of confusion about exactly where in the building Mr. Comenzo was living.
How is this case different from Mora? I know there's a time difference, but why should we not extend privacy rights and say this is a search?
Well, certainly the motion judge said it was a search based on the calculation of the length of the surveillance being, I think the judge said 17 days, and the Commonwealth's position is the amount considered for the purposes of this motion should have been the time up until the warrant was, if the affiant ended the observation for the purposes of the warrant. This case is different from Mora because this case isn't a drug case. It seems that most of these cases involve narcotics or firearms. This case is different in large part because this was a cyber crime being committed from a particular structure. And at the time police.
But how is, you may be going to go on and explain, but how is that different? The privacy interest is the police looking at someone's comings and goings, who visits and et cetera. What difference does it make what crime is being investigated?
In this case, there was less surveillance, significantly less surveillance than in the Mora case. I believe Mora was 169 days and then 62 days for the other house. Here it was 12 days approximately of actual surveillance. There was a break. The camera stopped working for a couple of days, so there was certainly a break in the surveillance. So the Commonwealth doesn't disagree that there is a privacy interest in one's home. The question is, when does the time cut? When does it become something for which a warrant is required? Here, the court need not even reach it because the judge did find that.
Doesn't this detect personal information? I may be misremembering the record, but for example, don't they see that somebody visits him at 3 a.m. and the lights immediately, or late at night and the lights immediately go to man? Then another time it's a woman and the lights immediately don't go on, they go off. That's odd, right? It gives you some personal information. People are visiting him late at night and the lights go off.
I mean, it is what the camera showed, but certainly that's something that had police been there, they could have seen it. Now, again, it is different. It's a camera, so the camera does record a lot more than what a person could have recorded. Other people in the building may have been aware of somebody coming up and down the stairs. But I suggest here, where the judge did find did satisfy the Mora test, a search is going to capture some sort of information about a person, about an individual's life. That's why probable cause is required.
Can you help me out on how we're supposed to count the days? Because as counsel points out, and Amiki points out, we usually look to evidence gathering versus evidence that's used. And here they didn't take the poll camera down, given logistics or whatever, but what analogy should we draw, or how you get to a truncated version of the days?
Here, the whole purpose of
Is there any cases you have or anything that's useful for our analysis in this area?
search warrant cases where what happens afterwards doesn't affect whether there was probable cause for the search warrant. So if the police went in there and didn't find evidence, it wouldn't mean they didn't have probable cause. Or if you go in there and you find something, it can't give you probable cause. You can't say, oh, well, we did have probable cause if you didn't at the time that the search was performed. And here, the affidavit wraps up with an observation, I believe, on the morning, and then the judge signed the warrant later that evening.
If the police have a search warrant for an apartment and they go into the child's bedroom and they don't find any evidence in the child's bedroom, they've still searched the bedroom. There's still a privacy violation, right?
If we're looking at a warrant, I mean, if there was a warrant to go in there, it's certainly somebody's privacy in their bedroom. Certainly from a personal view, yes, that person would likely think their privacy had been violated, but there was a warrant to search where a court had said there is probable cause to go in there and conduct a search.
So I think if we take the defendant's argument, part of the argument is that he could have been arrested anywhere. He didn't have to be arrested in the apartment. So keeping in mind that this search was about, what, 6 years before Mora came out? And we've got this two-part test. Assume there's probable cause to believe that a crime's been committed based on all the information before the poll camera went up. And putting aside the first test of the second prong about whether there'd be evidence of such an offense, just put that aside for a minute. Then the next part is, as we've been talking a lot about, will aid in the apprehension of the person. So I think that what the defendant is saying is it won't aid in the apprehension of the person because it could have picked him out outside of his apartment anytime. Why are they wrong about that?
In this case, the police had probable cause to believe this crime was being committed. They had probable cause also, I suggested it was Mr. Comenzo committing this crime. But the poll camera footage, again, showing Mr. Comenzo at that building provided additional evidence.
I understand that, and that may just be it. You may be absolutely right. That may satisfy, you got the first prong satisfied, and the second prong has two parts. We're putting the first part aside. And the second part, you may absolutely be right, that knowing the particular apartment is helpful for Article 14 purposes, as Justice Kafka said, as Justice Georgia said, it's going to aid in letting us know which apartment it is. But I'm just trying to get but the defendant has a response to that, as to the second part of prong 2. And their response is, no, it doesn't aid in the apprehension because you did have probable cause and you could have arrested him outside of the apartment at any time. That's what they said. What's your response to that?
It aided in the identification of the perpetrator, and the identification of the perpetrator aided in the apprehension of the perpetrator.
Wasn't there, we're here, surveillance of the defendant by police officers so that they knew that he resided or attended 15 Walnut Street before? They didn't need the poll camera for that.
They had information from traditional surveillance of him, his car being there, him being there, seeing him coming in and out, seeing him opening the door with the key. They did have that, but the poll camera gave additional information. So it did give them additional.
It certainly gave
information.
additional information, which is why it was a privacy violation. The question, I think, for prong 2 of Mora, at least as articulated in Mora, is how it aided in his apprehension.
It aided in his apprehension by contributing to his identification as the perpetrator. Finding that electronic devices connected to him in the apartment he lived in aided in the identification of the person who was uploading the child sexual abuse material.
Was there a matching between when there was an upload of the child pornography and the timing of Mr. Mora being at his apartment?
No,
I'm sorry.
he was not,
Mr. Comenzo being at his apartment?
no, there was never a matching of
All
him
right,
being
so,
there.
there isn't any connection between the crime and his physical presence there.
No, Your Honor, the connection was between his computer, which was found through the search, which was premised in part on poll camera surveillance indicating where in that building Mr. Comenzo lived and had access to.
So the poll camera shows him coming in with his computer? I'm confused by your connection.
No, the poll camera shows Mr. Comenzo coming in and out of the house. I don't
Right,
think it
as
ever
the
shows him
physical
with the computer.
surveillance had
Right.
done before.
Right.
So-
If I could follow up on Justice Wendland's part, because this is the issue that I had with the identification part. I forget the name of the case, but there was another case where it happened to be that there was another occupant of the residence that it wasn't the apartment holder or the lease, the person on the lease. It was somebody else that was physically in the unit. So there arguably could be some need to see who's there and who's not. They knew who was coming in and out prior to the poll camera. So there wasn't, the poll camera didn't help them identify whether somebody else was going in and out that ostensibly could have been doing the uploading. So they had known before that it was just Mr. Comenzo going in and out. So I'm still struggling with how could it help identify him when there was no evidence that anyone else was going in and out that it would arguably be helpful to.
Well, there were other people observed going in and out. I think that's a large part of the defense argument, is that other people were coming in and out of the building. This was establishing which part of the building Mr. Comenzo was accessing when he was going in and out of the building, which would again lead police to the particular device where the child sexual assault material, there was reasonable belief, probable cause to believe would be found on his devices, not someone else's devices.
So is your position that the Mora test was misarticulated and that actually it should be, the second prong should be aid in the, not just the apprehension of the defendant, but aid in the investigation generally?
I wouldn't say it was misarticulated. I would suggest it's the identification of the perpetrator is always going to be part of the investigation. And I suggest that's always going to be part of looking to apprehend the perpetrator is who is it? Who are we looking for? So, and I would suggest this case is somewhat different than the other cases and from Mora because this is not a narcotics investigation where perhaps there was interest in who was coming and going. The interest here was in the person who was there, what parts of the building was that person using.
Right, so you already had identified the suspect, you were just gathering more information.
Yes, a suspect had been identified and
Right, so the poll camera actually aided in the confusion because there were other people coming in and out of 15 Walnut. It didn't actually aid in the identification or the apprehension of this particular person.
well, it aided in the identification of this particular person's whereabouts in the building, which allowed police to find the electronic devices that this particular person was using to commit this particular offense by uploading.
Satisfies the first part of the second prong, and that may well be as well. And I understand what you're saying is the police cannot, under Article 14, just sort of flip a coin and say it's apartment 2 or apartment 3. They need the particularity. But I think what the defendant's saying and some of the questions are getting at is how literal is that about apprehension of the person? Because again, the defendant's saying you don't need the poll camera to apprehend the person. You can apprehend him right on when he comes out the front door.
Your Honor, I believe there is at least one case that says the police don't need to arrest a person at the moment that they have
I
probable
understand
cause.
that. I understand that. I'm just trying to figure out whether or not in this case, the second way to satisfy the second prong of Mora is satisfied with that language. That's all.
Can I ask a sort of a really simple, and I may be misunderstanding it, but So the cops aren't watching the house all the time, right? They have this poll camera up. It'll tell them when he showed up. Won't that aid in the apprehension of him?
Well, it won't tell them specific, I mean, they can go look at the footage and
Aren't
see.
they can't monitor it simultaneously?
Someone presumably could monitor it simultaneously and
that-
then say,
would
go
that-
now, he's there. That's true.
So would that aid in the apprehension of him?
I suppose it could. I don't think there's anything in the record to suggest that the defendant's
They may not-
whereabouts were
They might not
unknown.
need it, but, you know, they can track him that way when he's there and arrest him, right?
I wouldn't say so much track him, but they could certainly look at the footage and discern when he was there. And if the police say gathered somewhere else and discern that he was
So the
present.
first day they put the poll camera up, they're watching the poll camera. They see which unit he walks into and they see he's there, and they go arrest him. Does that meet the Mora test?
I think it would, Your Honor. I mean, I think that would meet the test, but I think that would meet the test.
Okay, thank you.
Thank you.